G'day YouTubers, and welcome to the first video of the AusAware channel. You may have heard the phrases data retention or metadata been tossed around in Australian media lately. But what do they really mean, and what changes are going on with government policy that are worth knowing about? The government have recently amended the Telecommunications, Interception and Access Act of 1979, otherwise known as the TIA Act. The TIA Act and subsequent amendments protect the privacy of users of the Australian telecommunications system by prohibiting public surveillance. Exception can be made for law enforcement agencies to access data with or without a warrant, depending on the data type. ACO, ASIC, the ACCC, Customs, the ATO, state and federal police, and local, state and federal governments are primary operators under the Act in the investigation of domestic crimes, corruption, missing persons, child pornography, sexual slavery, and terrorism. Review into the 1979 TIA Act and mandatory data retention was started by the last government in as far back as 2010. This was to reflect the changed landscape of telecommunications data in the present day and address an identified need for national security reforms. In mid-2013, the Responsible Review Committee handed down a report entitled Report of the Inquiry into Potential Reforms of Australia's National Security Legislation. Draft legislation was drawn up reflecting the recommendations in this report and was tabled in Parliament in late 2014. This bill was amended further through the Parliament, and the 2015 Amending Act to the 1979 TIA Act has now been passed by the Parliament. This bill amends the TIA Act to standardise the types of telecommunications data that service providers must retain under the Act and the period of time for which that information must be held. The bill also, amongst other things, defines which agencies can have warrantless access to certain types of telecommunications data, known as metadata. But what is metadata? Well, if you ask the Australian Attorney General, he might tell you this.
But the metadata is the phone number from which the call is initiated, the phone number to which the call is made, the identity of the owners of those numbers, the location from which the call is made, and the location of the recipient of the call.
The time, the duration.
The time, the duration. That's metadata.
It gets more complicated when you talk about online.
What you're viewing on the internet is not what we're interested in.
But that is telling you where I've been on the web.
Well, it records what what electronic web address has been accessed.
Layperson's definitions vary from data about data and information generated by a telecommunication but not the communications itself. Currently, there is no positive definition of metadata under Australian telecommunications law. This is primarily as there are conflicting views on what comprises the content of a communications around the internet, and to keep law open-ended around the issue as technology evolves. Metadata is negatively defined in the TIA as being telecommunications data excluding information that is the contents or substance of a communication, or documents to the extent that they contain the contents or substance of a communication. Access can be granted to law enforcement agencies to existing telecommunications data with or without a warrant. Content of telecommunication requires a warrant, either in the form of an interception warrant for phone or stored communications warrant for email. Metadata, however, does not require a warrant to be accessed by enforcement agencies. Voluntary disclosure is permitted where an employee of a telecommunications provider encounters information they regard as being in connection with ASIO's functions or reasonably necessary for enforcing criminal law. ASIO and authorised senior officers within enforcement agencies can authorise disclosure of metadata from telecommunications service providers without a warrant. The aim of these exceptions is to support national security and law enforcement in investigations into crime. Over 80 organisations have requested and been granted access to this information under the 1979 TIA and its amendments. There were more than 300,000 authorisations allowing agencies to access this metadata in the 2012-13 financial year alone. These were not necessarily law enforcement agencies such as those previously mentioned, but included groups such as the Australian Health Practitioners Regulation Agency to ascertain a breach of ethics on a doctor having a relationship with a patient's spouse, Bankstown City Council to prosecute illegal waste dumpers in the community, and Wyndham City Council to track down and prosecute the owner of a dog that attacked an elderly man. In 2011-2012, the most requests for metadata came from Centrelink, who contacted telecommunications companies 1,181 times. Although these requests for stored information are often made and approved, the 1979 TIA did not prescribe the type of information required to be retained by telecommunications providers, nor did it describe any minimum period of time for which it was required to be retained. Without any standardisation of this, individual telecommunications companies retain metadata based on business, taxation, billing, and/or marketing requirements, or as a side of the function of their telecommunications infrastructure. The types of data available to law enforcement agencies and the period of time that information is available therefore varies greatly across the telecommunications industry. A phone metadata example of this would be Telstra keeping call duration blocks to bill the user for a particular billing cycle, which is then not needed in that form beyond the bill date. An internet metadata example would be Google keeping your search history for relevant periods of time to use targeted advertising until such a time that your habits are deemed to change. However, the type and amount of metadata being held by telcos is changing towards volume-based billing, such as blocks of time or credit, and away from the call-by-call based billing system as usage and technology changes. This means telcos no longer need to keep the same metadata that was once required. This is becoming a problem for the enforcement agencies that utilise metadata as part of their function. Enter the Telecommunications, Interception and Access Amendment Data Retention Bill of 2015, which we'll call the 2015 Amending Act. The direct beneficiaries of the Amending Act are primarily law enforcement agencies. The enforcement agencies will have an increased duration of retention of metadata by telecommunications companies, going from what was currently quite variable to 2 years. They will have an increased efficiency and ease of access from telecommunication companies in providing the information, as the legislation provides a more streamlined process. The shift in billing methods, particularly from phone companies away from metadata intensive methods, has now been halted, and there is also particular certainty and control over metadata that is collected, as the government will now specify these and update this through regulations. In summary, the 2015 Amending Act requires telecommunications companies to retain customers' phone and computer metadata for 2 years beginning in 2017, as opposed to the undefined duration under the 1979 Act. The metadata to be retained will be defined through government regulations, but not positively defined in the Amending Act. The bill will detail which agencies are able to have warrantless access to this data. This is going to be reduced to around 20 law enforcement agencies, including the ATO, the ACCC and ASIC. However, other agencies can apply to be considered an enforcement agency. These agencies will then have access to the metadata when they can make the case that it is reasonably necessary to an investigation. The Act gives the Attorney General broad discretion on which agencies can access metadata and whether they enforce the criminal law, impose penalties, or protect the public revenue, or any other matter considered relevant in allowing access to metadata. The Act requires that agencies who are not an enforcement agency for the purposes of the Act must be declared by the Attorney General to be an enforcement agency before they can authorise the disclosure of telecommunications data. The Act still requires security agencies to obtain a warrant before accessing data content. In addition, metadata related to journalist sources and whistleblowers will require a warrant to access, and the scheme will require a review every 3 years. So where do the political parties stand on this? The Liberals introduced the bill and argue that the laws are necessary because internet companies are not retaining the data and there is not the efficiency in their system needed to catch pedophiles, terrorists and other criminals. The primary purpose, according to the Attorney General, is that of anti-terrorism. Labor have agreed with the scheme in its current form, requiring a handful of amendments, and therefore allowed it to pass the upper house. The Greens have questioned the necessity and effectiveness of a blanket surveillance technique when weighed against civil liberties, and a large majority of minor parties in the Senate voted against the Amending Act. That long, boring summary may lead you to think that everyone was happy, except a couple of politicians. Well...
You may be wondering why there is this opposition in Parliament. Who else disagrees with or has concerns about the Amending Act? There's actually a broad range of concerned groups who are pretty pissed off, such as the telecommunications companies themselves, privacy groups, civil rights groups, legal groups, journalists, technology and IT groups, and political groups as mentioned.
It is considered there are many unresolved issues with the logistics of the passed bill. This includes security of information. The government proposes that telecommunications companies pull together metadata into centrally accessible locations. Storage and security issues will be in the hands of the telcos. Small companies will most likely store metadata overseas as it's cheaper. However, this will not be under Australian law about exposure of data breaches. This leads to possible security breaches and targeted attacks by hackers after the honeypot of personal information. In fact, days after the passage of the Amended Act, Optus admitted to 3 large privacy breaches that had occurred in 2014 alone. This included the names, addresses and phone numbers of 122,000 Optus customers listed online without consent, leaving hundreds of thousands of modem management ports open and vulnerable with default username and passwords, and allowing hackers potential access to Optus customers' voicemail between September 2013 and May 2014. Interest groups are concerned that the frequency of cyber attacks and the effect of such breaches will only be exacerbated with such huge concentrations of data. There are also concerns about how telcos will use this new data and whether current protections under Australian law are adequate in dealing with unanticipated uses and disclosure to third parties. The cost of retaining information has also been identified as a major issue. The cost estimates range from approximately $200 million to $400 million set-up cost for telcos, and the government has committed to contributing $131 million in the 2015 budget. The most likely outcome of this is that telecommunications companies will increase the cost to the consumer to cover their costs. Last year, iiNet slated a potential increase in billing costs of around $5 to $10 a month for end users. The increase in cost will also have an effect on the competitiveness of the telecommunications industry. Smaller companies will potentially not be able to afford to make the required infrastructure changes. There is potential for company closure, with at the very least company losses and investors being out of pocket. Concerns also arise around potential scope creep of metadata collection. Under the Amended Act, metadata is not positively defined. That is, it broadly says what metadata isn't, but not what it is. The Attorney General not only has control over which agencies can access metadata, but the government will regulate what is defined as metadata. This will be done through regulation, which is much easier to be gazetted and changed than a legislative act. The worry is that government regulation can begin to collect further, more intrusive information as it is generated by new technologies as the government controls what new data is defined as metadata. What the metadata is used for in future is also of concern, such as scenarios where the information can be used by authorities in litigation unrelated to crime prevention or national security. Also, you don't have to have an elaborate tech setup to bypass metadata collection in Australia. It is considered by industry experts that serious criminals will easily circumvent the scheme, with workarounds available for almost all forms of telecommunications. This has been evidenced already in Australia with both the internet and phone networks. Bikies have already started using encrypted imported Blackberries from Mexico to circumvent the system. Even heavy proponents of the scheme have acknowledged that it'll not only be easy for criminals,
But this is also for terrorists too, arguably, and child sex offenders as well. There are ways to get around this.
There are always ways for people to get around things.
but even the average punter.
This is a way to get around data retention, isn't it?
It's a way to
retain that stuff.
Yeah, well, you see, if you have a device, a phone, a smartphone, and if I call you just through the telephone, through the mobile phone network, then there will be a record at my carrier. Let's say my phone is with Telstra, then there's a record at Telstra that I've called your number. If, on the other hand, I communicate with you via Skype for a voice call or Viber, or I send you a message on WhatsApp or Wicker or Threema or Signal or, Telegram, and there's a gazillion of them, or indeed if we have a FaceTime call, then all that the telco can see insofar as it can see anything, is that my device has had a connection with, say, the Skype server or the WhatsApp server.
But not with me.
It doesn't see anything happening with you.
Any service that goes through overseas providers like Gmail, Yahoo, Hotmail, Facebook Messenger and Twitter direct messages will not be picked up by the scheme. This is not to say other countries' data retention schemes won't get it. A VPN, or virtual private network, is already a common way for about 16% of Australian internet users to protect their identity online. A VPN replaces their computer's IP address with a VPN provider's. This gives the appearance of the computer being in a totally different location to where it actually is. VPNs are useful in the home and business for security, efficiency and privacy reasons. Celebrities are particularly frequent users. This protects them from association with their browsing and downloading habits from the prying eyes of end users of metadata.
Can't hit cause they can't see. I'm out of sight, now I'm out of they dang reach.
It is also argued that the new laws will not stand on the grounds of human rights violations. Similar schemes have been declared a breach of human rights by just about every court that has examined them. The 2006 EU Data Retention Directive was successfully challenged in courts by many European countries. The ultimatum was then delivered in the Court of Justice in the European Union. The Data Retention Directive was found invalid in April 2014 as it was in breach of EU human rights law. In particular, this included the right to privacy and data protection and the psychological effect of mass surveillance on citizens. The blanket data retention scheme was deemed not necessary nor proportionate as it applied to all persons and all data with no evidence of any link to serious crime or threat to national security. Industry experts also claim there is a false distinction between metadata and content. The majority of national bodies tasked with metadata collection claim metadata is a much more useful tool in painting a picture of someone's life than telecommunications content. This is considered particularly true with the complex and high-level data analytics tools that are available to enforcement agencies. As NSA General Counsel Stuart Baker has said, metadata absolutely tells you everything about somebody's life. If you have enough metadata, you don't really need content. Michael Hayden, ex-chief of the United States NSA, has had this to say about the informativeness of metadata to America's drone program.
Okay, we kill people based on metadata.
The proportionality of blanket data collection regimes versus their effectiveness has also been called into question. The Act carries, and has done so for years, the ability for enforcement agencies to issue preservation notices without a warrant. A preservation notice issued by the enforcement agency requires telecommunications companies to retain all metadata related to a potential interest. Subsequent access to the metadata can then be obtained under the Act. It is argued that similar effectiveness can be achieved with targeted schemes around preservation notices as opposed to blanket retention and the proposed treatment of everyone as a suspect. The effectiveness of blanket phone data retention to prevent terrorist acts has been shown as virtually ineffective. Bulk collection of phone metadata in the United States, examined by The Guardian, has been linked to only one known case of terrorism prevention. This case was a San Diego cab driver donating to an Al-Qaeda affiliate. The same study showed that identifying recruited members of US-defined terrorist groups using phone metadata was also effective in only 1.8% of cases. Serious concerns have been raised about journalist sources and whistleblowers being revealed and persecuted. Journalists will not be informed if their data has been requested by enforcement agencies to determine their sources. Therefore, they will not be able to contest the request. The Attorney General's discretion to declare what a criminal law enforcement agency is has also raised eyebrows when considering motivation to identify government whistleblowers. Lack of definition in the Act and advances in technology have caused concern over whether the proposed browsing history exclusion is really an exclusion. Although the government has repeatedly stated it does not want it, the Act does not specifically state that telecommunications companies cannot collect browsing history. It is considered that there will be circumstances where it will be easier and less expensive for a telco to retain browsing history in order to retain the metadata associated with it that the government requires. In particular, the phasing out of an old IP address system will mean that the only way to record a source IP address, that is the number identifying the computer of someone browsing the web, is to also record the destination IP address, the server and therefore website of the page that they are browsing. The last one to mention in the video, but definitely not least, is the right to privacy of the individual and the police-state mentality. Many believe the blanket retention mandated by the government is the start of an irreversible incursion of intervention and surveillance into people's lives. Note that this is not just our government. The Amending Act does not identify how metadata will be shared and used by the other partners of the intelligence group Five Eyes. This includes Canada, New Zealand, the United States and the United Kingdom. Thanks for watching, and I hope this video may help you learn something or answer some questions that you may have. Please indicate if you liked or disliked the video, or if you could also leave a comment with feedback on what you would like to see more or less of, or just general feedback, please do. The next video on the series out soon will be on the Trans-Pacific Partnership. Thanks Oz and beyond, or whatever country you're from, and always remember, stay aware.